My name is Kerry Jack and I work on behalf of Brodie Jackson Cantor. And I'm very pleased to tell you that I'm joined by an expert legal and counsel team this evening. So we have Nicola Brook from Brodie Jackson Cantor and counsel Pete Weatherby KC, Mira Hammad, and Jessie Nicholls. So welcome to you all and thank you for joining. For those of you that haven't been on one of these sessions before, I just explained the format to you. It's very simple. It's just designed to allow your legal team to be able to update you on what's currently happening and for you to have the opportunity to ask them questions. And we've got quite a lot to get through this evening. We've got 5 specific areas we're going to be covering off, and I'll just run through those first of all for you. First off, we're going to start with the Module 2 preliminary hearing and the Chair's ruling on our submission, which we received yesterday. And Jessie is going to talk us through that. Mira will be talking us through the most recent developments around the listening exercise, and particularly in relation to the appointments of Ipsos Mori and MC Saatchi. Nicola will be discussing Module 3, which opened earlier this week. Pete will talk us all through the Rule 9 requests, and then back to Nicola, who will give us an update on plans to liaise with other core participants. So the plan is, at the end of the hour, you should understand the outcome of Module 2 preliminary hearing, what our plans are for Module 3, and our next moves on the listening exercise, and what all 3 of those mean for you moving forward. As ever, we really do welcome your questions, so please do type them into the questions section that you can see in the webinar's navigation on your screen. Tonight, we're going to focus all of the questions around those 5 areas that I've just mentioned, but if you do have any other questions that don't relate to those areas, please do still mail them in, but we may not get to them on tonight's session. But let me just ask you to take a look on the Brodie Jackson Cantor website, where there is already a very comprehensive FAQ. I think Chris will be able to add that to the chat now, so that you've all got the link. Any questions that we don't get to answer this evening, we will mail you back directly to give you an answer in the next few days. And then all of the questions from tonight's section will appear on that FAQs that I mentioned just. Couple of words on the difference between the Q&A section and the chat section. We do monitor the chat for questions, but you will increase your chances of getting your question read out this evening if you pop it into the question area, not the chat. But rest assured, Elkin is behind the scenes for us this evening on the chat, and will be able to engage with people there. And on the chat, some of you don't want to engage in that, and that's absolutely fine, total personal choice. And if you don't want to, and you want to disable that chat function, just simply press the chat icon on the toolbar along the bottom of your screen to just hide the chat box. And let me remind you, the chat remains a valuable and safe place to air all of your views, and we do thank you for keeping it that way. So let me ask Nicola now if she would introduce herself and her fellow panelists.
Good evening, everyone. I've got a slight cough, so sorry if I cough and splutter a bit tonight. I'm a solicitor. I work at Brodie Jackson Cantor, and I am working alongside Elkin on this. I was previously taking a leading role representing bereaved families in the Hillsborough inquests, and I was responsible for our team on the Manchester Arena inquiry. I will be your main point of contact for you on the COVID inquiry on a day-to-day basis. I am joined tonight by Pete Weatherby KC. He is our lead barrister, and he's the most regular panelist. You will have seen him most. He led our team on the inquiry at the preliminary hearing. He is a human rights specialist and has led teams in many of the UK's highest profile inquiries and inquests, including Hillsborough and Manchester Arena. Also here tonight is Mira Hammad. She is also a member of our counsel team, representing you in the inquiry. She is a barrister at Garden Court North Chambers and specialises in inquests and inquiries and criminal defence. Mira also previously worked with us on the Hillsborough inquests and was also part of our counsel team on the Manchester Arena inquiry. Finally, Jesse Nicholls, he is also a member of your counsel team. He's a barrister at Matrix Chambers and specialises, amongst other things, on judicial review, inquests and inquiries and human rights law. Jesse previously worked as counsel to the inquiry on the Manchester Arena. He also provided us with advice on the Manchester pub bombings, and he also attended the Module 2 preliminary hearing on your behalf alongside Pete.
Thanks for that, Nicola. Then just a final few words from me on confidentiality. Everyone on today's webinar is bound by the same duty of confidentiality. Any questions you type in will be answered personally in the days followed the session. All questions you ask are anonymous and no personal details will be shared. The attendees on today's webinar are either clients of Brodie Jackson Cantor, PA Duffy and UK-wide members of the COVID-19 Bereaved Families for Justice group for whom Brodie Jackson and PA Duffy act for. The webinar is being recorded as usual and will be edited if necessary to ensure that it doesn't include any clients' personal details. So without further ado, I am going to ask Jesse if you would please update everyone on the Module 2 preliminary hearing.
Thanks very much, Kerry, and thank you everyone for joining. I'm going to talk through the issues that arose at the Module 2 preliminary hearing and the Chair's ruling that we received yesterday. I'm going to do that in a little bit of detail because it's dense stuff and important, and a number of issues were raised, but I'm going to try and keep it also relatively brief so that I don't bore you and so that you will have time to ask questions and other people have time to make their contributions. A short word by way of introduction. The context in which I'm updating you is, as Nicola touched on in the introductions, along with the other members of the legal team, I've had extensive experience in working in most of the major recent public inquiries. Manchester Arena, Grenfell, currently involved in the Novichok poisoning inquiry. And the reason I say that is because it's relevant to an understanding by comparison of the approach that the inquiry team are currently taking in this inquiry. And some of you will probably know what I mean by that when I say that, but I'll come on to be completely blunt and clear about it in a few moments, all right? The final point to make by way of introduction is that there will be, I'm sure, useful contributions from other members of the team, including Pete, who was obviously carrying out the advocacy on your behalf at the 2 preliminary hearing. So others will chip in either while I'm speaking or afterwards in case they have additional thoughts or feel that there are additional points that I've missed. I'm sure you all know what Module 2 concerns. You'll probably have seen the Module 2 scope document. In very broad terms, Module 2 concerns the response to the pandemic by central government and related bodies. And it's summarised at various points in the scope document and also in the submissions that counsel to the inquiry, who are so far being represented essentially by Hugo Keith, King's Counsel, at the hearings, the written submissions that they provided. And they basically say that it will consider and make recommendations about the UK's core political and administrative decision-making in relation to the pandemic between early January 2020 until restrictions were lifted in February 22, including paying particular scrutiny to the decisions taken by the Prime Minister and the Cabinet as advised by a range of others. All right, and so that's the focus of Module 2. Now, for those who don't know, although I know many of you will, the Module 2 preliminary hearing took place on the 31st of October, and we had a ruling, very short, issued yesterday off the back of the hearing by the Chair. Now, I'm going to go through the headline topics that arose, the arguments that there were, and effectively what the Chair's ruled on those points in a moment. but I think it's necessary for me to start by saying that what I'm going to go through in a moment is not positive or particularly uplifting. All right. And I'm sorry that that's the case. There are still things that I think we can do about that. And I'll come on to touch on those at the end, including why it's important that we maintain our course and adopt the approach that we are taking. So I'm not being defeatist, but I'm necessarily giving you a realistic update on the disappointing limits of what we're seeing so far in the 2 preliminary hearings that we've had. All right. The headline from the Module 2 preliminary hearing is that in many respects, they have maintained the inquiry, that is, similar or identical positions to the ones that they adopted at the Module 1 preliminary hearing that we did not agree with, and for good reasons. And at the moment, that is having the effect, in my view, and I think in the view of the rest of the team, that the inquiry's approach is hampering the kind of meaningful and effective participation that we want on your behalf and which we're seeking to achieve. And that as a result, unfortunately, they are hamstringing their own ability to do an effective job, because ultimately our participation on your behalf is designed to ensure that the inquiry is itself effective. And indeed, that's what the group has always sought to achieve. Now, let me go through some of the headlines. Before going on to the topics that were touched on at the hearing, the first is to say that the Module 2 hearing involved a greater number and range of non-state representation, by which I mean people who are given core participant status, like this group, from a non-state background. And that included long COVID groups, disability rights groups, groups who were involved in providing services for women who suffered domestic violence and abuse during the pandemic, and others. We consider that that is a positive development. I'm afraid it didn't result in substantial positive changes to the inquiry's approach, but we think it's a positive development that there are a broader range of non-state bodies involved, essentially because they are likely to bring further perspectives of those who suffered in different ways during the pandemic, rather than simply bringing another range of defensiveness from state and institutional court participants. Second, their presence potentially adds weight of numbers to a number of the points that we are already making and may give them greater force, although there are limits to that, as we've seen. And in practical terms, they are likely to align with us and support a number of the things that we are saying and asking the inquiry to do. And indeed, we saw that in the written submissions and the oral submissions that they provided at the hearing. Now, in terms of topics, the headline ones I'm going to go through now. First, scope in relation to Module 2. The position that the inquiry set out in writing and then orally, and essentially what Mr. Keith says orally is always the same as what he's already said in writing, basically reading it out, is that the scope document for Module 2 was considered to be ambitious but adequate, and that the inquiry was willing to listen to suggestions for amendments. Now, there were some positive indications that the inquiry was willing to listen to amendments as a result of both our submissions and the submissions of others. And I think Pete is going to touch on that briefly when he updates a little later on. So I'm not going to go through the details of that. The second topic was Rule 9 requests. Now, I know that a number of you already know what these are, so I apologise if you do, but as I'm sure many of you know, they are requests from the inquiry to individuals and organisations for essentially evidence, material and information that may be relevant to the inquiry's terms of reference. And the inquiry has told us in relation to Module 2, as it did for Module 1, that the inquiry has made numerous requests. They are apparently lengthy, complex and wide-ranging, and the inquiry has been at pains to emphasise that it's conducting a thorough exercise. Now, as you may already know from our submissions in Module 1, we want to see those requests so that we can consider whether they are, in fact, as lengthy, complex, wide-ranging and effective as the inquiry has said that they are. And so far, the inquiry has refused us access to those documents. Now, that is not unprecedented in other inquiries, but we think there are good reasons for them to be disclosed in this inquiry. And indeed, there has been a development in the Module 2 hearing, which we say and said at the Module 2 hearing made that even more important. And that was, in short, that the inquiry made clear that based on the responses it's receiving so far to its requests for material, particularly from central government departments, the amount of material runs into the tens of millions of documents. And in those circumstances, there is a concern from the inquiry that the review that needs to be conducted of those materials by both government departments and then the inquiry would mean that there would not be disclosure to core participants for a number of years. Now, as a result of that, the inquiry has proposed what it's describing as a more targeted approach, and that essentially involves focusing on what they're describing as key narrative events, decision-making procedures of key bodies and persons, and then making further focused requests as a result of that. Now, CTI maintained the position that the inquiry should not, despite that change of approach to disclosure, which we can understand the reasons for, although we have concerns about, should still not disclose the Rule 9 requests to us and other core participants. Instead, what the inquiry is now proposing to do is provide monthly updates in general terms, setting out what the Rule 9 requests are doing. Our response to that was to say that in light of the new targeted approach, it was even more important that the Rule 9 requests should be disclosed to us and other core participants. The reason for that is because if the inquiry is placing a greater onus on central government departments and others to identify what they consider to be relevant based on some key narrative events, there is a greater risk that material will not be provided and that you and others will not have confidence in the process because we haven't seen what's being asked for and what's being provided in response. And so not only did we say that it was necessary for confidence reasons for them to give those documents to us, but also so that we could assist the inquiry by pointing out gaps or areas of improvement in what they're asking for. And a number of the other new non-state core participants essentially supported us in that request, both in writing and at the hearing. I'm afraid that the response of the inquiry team to our submissions on this point was, in my view at least, the lowest moment of the hearing. And that involved Mr. Keith in his reply saying openly, in effect, that the real reason why the inquiry should not and would not disclose Rule 9 requests and other related documents to core participants is because if they did that, what we and others would do is read them, assess them, make further requests as a result of what was missing, and suggest constructive observations. And if we did that, that would place a significant burden on the inquiry because the inquiry would then have to read what we'd said, consider what we'd said, and potentially do something about it. Now, I'm afraid that in my view, that revealed a fundamental misunderstanding of the purpose of conferring core participant status on the bereaved and on others more generally who have a status within the inquiry in order to understand what's going on and make the inquiry better. Unfortunately, Mr. Keith indicated that really what the inquiry wants to do is its own work without anyone else disturbing it, and then produce the results of that and say, it's all fine, we told you all along, you could trust us. And we don't agree with that. And really his reply was concerning and dispiriting, but revealing of the core nature of the inquiry team's current thinking. The chair essentially ruled on this in one paragraph yesterday and said that at the moment, Rule 9 requests and the related documents effectively would not be provided to us and others. And she wanted to allow the updates to be provided and for her to see how those go. Now, I should say that I have experience of other inquiries where, although there are concerns about the way in which the inquiry team expresses itself, there is significant positive work going on behind the scenes that we don't see that is effective at making sure that relevant material is properly being sought and obtained from those who are in the firing line. And I'm not at the stage yet where I think that what the inquiry is doing is seeking to facilitate some form of whitewash in which material is deliberately suppressed. I don't believe that. I do believe that the inquiry will still be trying to obtain the relevant material. The problem is they're not involving us in trying to do the same thing in a way that would make that more effective. So I am concerned by what they've done, but I wouldn't want you to think that it means that the inquiry has essentially put up its hands and agreed that it's going to allow relevant material not to be provided. That is not what I think is happening, but I think that they are in danger of compromising a degree of effectiveness because they're trying to move quickly. And one understands the balance there, but there's a concern from us about where they're striking it. All right. And I'll come on at the end, and I know I'm taking time, to explain why I think it's important that we keep raising these points and why we need to do that because of how things may develop. The next core issue that arose was around disclosure. Essentially, the inquiry said they'll be as open as possible and they will provide us with all relevant material that they have to provide us with, which essentially is all we've ever asked for. That they continue to say that it's not necessary or proportionate for the inquiry to disclose every document that it receives, but we've never asked for that, and no inquiry ever does that. So I don't find that to be a concern. I think we should expect that we will receive the relevant material. The key is to make sure the inquiry are getting the relevant material and conducting a process to do that, which is what we're trying to help them see. The next point that arose was on experts. Essentially, they are saying that there will be a number of experts involved, both as witnesses of fact, because they were relevant witnesses who were giving advice to decision makers in political positions at the time. And also they will have their own experts giving expertise and expert opinion now to the inquiry. Our concern on experts has always been that they've agreed that they will allow us to input into who those people are and what they're asked, but they seem to be proposing to do that at such a late stage that it won't allow for the most effective and constructive input. And so we've raised that again with the inquiry, and at the moment the inquiry has remained silent on that point, including in the chair's ruling, which is again a concern and something that we would not wish to see. That said, we will obviously on your behalf be making clear who we think the appropriate experts should be and the sorts of things they should be asked about to the extent that we're able to, based on what we know and have seen. The next issue was the listening exercise, which Mira is going to cover as a very important separate topic, so I'm going to move past that. The issue of commemoration and what's being described as impact evidence was dealt with again, but the inquiry essentially maintained the same position, that is, as in M1, Module 1, which is essentially that the circumstances of individual deaths will not as a general rule be considered in Module 2, save where it gives rise to evidence of of systemic issues, and that is likely to arise more in later modules in the inquiry rather than in Module 2. The remaining points that you may have seen in the ruling from the chair were that the proposal is for the Module 2 public hearing to take place in the summer of next year. There was a submission made on behalf of the Trades Union Congress that there should be a hearing called a strand tying hearing. That's a sort of complicated way of saying a mopping up hearing at the end of all the different Module 2 hearings to see what had been learnt and to tie it together. In her ruling, the chair said she wasn't currently persuaded to do that, but as with everything else, she said she's keeping this all under review. And the final point on our submissions is that we repeated our call for proper dialogue and communication with the inquiry team. And at the moment, there has been no substantive change in response from the inquiry on that. I anticipate that we will maintain that we need to meet with them, and we will have to start expressing perhaps a little more frankly our position on what they're doing and see where that takes us. But it remains necessary and important to keep open some form of communication with the inquiry to try and shift their thinking, especially as things develop and, as we fear may occur, are not as effective as they think they're going to be.
Jesse, thank you very much for that. Most comprehensive, not necessarily positive. Before I just hand over to Mira, Pete, is there anything that you can perhaps add, because there's been quite a lot of sort of disappointed chat, as you can imagine, on the chat function about whitewash and the way things are going. Is there anything that you can offer in terms of hope and positivity, or any other reflections that you would add to what Jessie's just said?
Well, I think that if we're looking for positives, first of all, the fact that the inquiry has chosen preparedness first, and then module 2 is the high level response, basically the ministerial response. And then we're going to come on later to module 3, which is healthcare. I think those are positives because they are probably modules that I might have chosen if I'd been asked. I wasn't, but I think they're a pretty good way of starting the inquiry. And a point about module 2 that Jessie made, but I think it bears repeating, is that in module 2, Lady Hallett has let through the door some more friendly core participants, core participants representing the groups that he's already been through, and I won't repeat. And there is some strength in numbers here, in the build-up of argument in the inquiry could have a positive effect. What we're talking about is a term that you will hear very often: effective participation. Jessie has very effectively just told you that there isn't any effective participation at the moment, because Lady Hallett and her team have effectively frozen us and everybody else, not just us, out. She's smiling, being pleasant to people, telling people that they're going to be put front and central, and then excluding them completely from the process. If they don't involve us in the gathering of evidence, which is this Rule 9 process, if they don't give us the list of issues on this targeted approach, if they only allow us to comment on the expert evidence at the point the expert's going to sign the document, which is their current position, then they are excluding you and us, your representatives, from the process of assisting the inquiry. And as Jessie's already pointed to, he's been involved in many inquiries. We all have. I did my first public inquiry in the mid-1990s. I can tell you straight between the eyes, I have never done an inquiry where I have been so excluded as this one. And it is a concern, but obviously you have quite a lot of experience within the legal team, and we will keep battering away until we get through that. That's our reason to be. Just finally on that point, Elkin has persuaded the inquiry team to have a reset meeting to try to get the relationship better. And that's going to take place on Tuesday. A couple of the directors of the group will be there with Elkin, and some of the campaign team will be there with him as well, with the inquiry team. The starting point isn't good because they have excluded counsel, so I'm not invited. That doesn't really matter. It's just the fact that they don't want counsel there, which is unhelpful. But I'm sure Elkin and the directors and the campaign team will do everything that can be done to try to persuade the inquiry team to change track. Okay,
thanks for that, Pete. Mira, I'm going to move over to you now, if I may, please, for an update on the listening exercise and Ipsos and M&C Saatchi, please.
Thank you, Kerry. I think it's important to start off with how we found out about this, because it goes to the issues that Jessie raised and then Pete raised about the way that the inquiry has been communicating with us. You all obviously will know that we've been asking the inquiry for more information about what it is that they're planning to do. We objected to the way that they were planning to contract out the listening exercise to companies. And yet, the way that we found out about it was when it was announced to everybody during the Module 2 preliminary hearing. And in fact, I know that Pete had specifically asked counsel to the inquiry whether there were any updates right before that hearing and was told, no, there aren't any. And so even though this is an issue that we've made clear is one that is really concerning, the inquiry didn't try and engage with us, didn't try and explain their position. They just announced it to everybody at the same time. So again, that fits in with what Pete was saying about the way that this inquiry is engaging. Now, on to what they've said specifically. So they've hired two firms, M&S Saatchi and Ipsos. And in effect, they're saying that M&S Saatchi also want to use a third firm, which is called 23 in Red. Now, the way that the inquiry has said that this contract will work is that in essence, they're relying on these companies to design and carry out the beginnings of the listening exercise. So what I mean by carry out the beginnings is they're going to be running pilot sessions, and of real concern to us is that the inquiry have specifically said that they're going to be advising the inquiry as to the approach that they should take in terms of how they will listen to the public, including who they will need to hear from, when, and what support is needed for people. They're also going to be coming up with a name for the listening exercise, communications plans and tools. Apparently, the inquiry is particularly relying on M&C Saatchi as a company that it says is very good at reaching out to hard to reach communities. And then it's relying on their experience for piloting in-person sessions, and relying particularly on Ipsos in relation to advising on emotional support needed, and also a plan for analysing online and offline responses. And it's going to ask M&C Saatchi to provide it with options for physical and digital commemoration. So actually, even though the inquiry has specifically said that the role of these companies for the moment is limited to sort of the design of the listening exercise, and it said, well, we are doing the listening exercise, but these companies are helping sort of set it up. As you will have heard from the communication and what the inquiry has said these companies are doing, they're making some really key decisions based on the advice that they're getting from these companies, especially who they're going to talk to, and what views they need to get and how they're going to talk to people. So that is really quite concerning. We don't know how big the contract is. We don't know how long they're going to be involved for. So the inquiry has said about 5 to 8 months. We know from press reporting, whether or not it's accurate, I don't know, that the contract for M&C Saatchi is worth about £800,000. So that sounds like a significant amount of work. That's not been disclosed by the inquiry. That's what the press are reporting. I don't know whether or not it's true. Now, the inquiry have said that M&C Saatchi are planning on using a creative agency called 23 in Red. The inquiry have, in essence, said, well, we're not saying that we'll allow them to use 23 in Red yet. And the reason for that is because 23 in Red were the company who ran the Cabinet Office's COVID hub. So they were managing the information to the public during COVID. And what the inquiry has said in their communication to us is, well, we're going to, it's not been approved yet, but if it is, then it will be with the appropriate safeguards to make sure that, you know, there's no conflict of interest. Now, to be quite frank, I don't think the inquiry would have mentioned this company if they were not intending to allow them to participate. I don't think we would have heard about them. And so I think in reality, even though the inquiry is saying, well, we're still thinking about it, more likely than not, they are going to allow the involvement of this company. There's also some issues in terms of a conflict of interest, or a perceived conflict of interest, with M&C Saatchi and with Ipsos as well. And I would say different levels. So in terms of our issues with the companies themselves, our essential starting position, and this is what we've said from the beginning, is that these exercises are not appropriate to be outsourced to companies, because corporate PR companies are not experts in dealing with issues like this. They're not experts in dealing with bereaved people. They're not experts in dealing with trauma, in dealing with holding the government to account. They're not experts in any of that. And so we've said what you should do, inquiry, is actually use expert authorities like, for example, Inquest, which is a charity which has campaigned on behalf of bereaved people for many, many years. The inquiry hasn't done that. So that's been our starting position. But in terms of the concerns about these companies, I think we are most concerned about 23 in Red and M&C Saatchi, and then third about Ipsos. Now, I'm going to address a little bit later the extent of conflict, the issue, why we're concerned, and what we might be able to do about it. But I'll leave that to the Q&A session, I think.
Okay, thank you for that, Mira. Nicola, without further ado, just because I want to make sure that we've got enough time for questions, would you give us a brief update on Module 3, please?
Yeah, I'll go through this quite quickly. So Module 3 was opened earlier this week. As with other modules, we weren't told about it. We just happened upon it once when we went on their website. There was no advance information about it at all. So the focus of this module is healthcare. It doesn't cover all frontline workers, so we need to assume that they will be dealt with in a later module. This module will look at the decisions that were made and also the impact of them. There is specific reference to DNRs, which I know is a major concern for many of you, so that will be investigated in this module. There is also specific mention of the telephone advice service 111 and the 999 ambulance service. And these are precisely the areas where we would be lobbying for your stories to be heard directly by the chair in the evidential hearings, not in any kind of parallel process. So we don't have any information about when the substantive hearings will actually go ahead. But if any of you listen to the hearing for Module 2C, that covers decisions in Northern Ireland, those hearings aren't going to take place until the start of 2024. So it looks like Module 3 will be sometime later in 2024. So next steps, we need to again apply for CP status on your behalf. We have a deadline of the 5th of December. So we will take care of that. We will get that drafted on your behalf and get it submitted. So you don't need to do anything. We'll just take care of that. I don't know whether we'll get an answer on that before Christmas or whether it'll be early in the new year. But as with everything, as soon as we know, we will pass that on.
Thank you, Nicola. Pete, I'm going to come over to you now, if I may, on Rule 9 requests, please.
Yeah, I'm going to be very, very quick because I'm conscious that we need to get to questions quickly. We've had a Rule 9 request from the inquiry for Module 2. So what that means is that the inquiry, although it's generally not speaking to us, has requested that we send them whatever evidence that we have that might assist them on Module 2. So perfectly positive, no problem with them doing that. They're particularized what they're asking us for. Some of it is to do with the organisation, CBFFJ itself. That can be dealt with by the directors or the campaign team. But things that you might think about, if you have been collecting articles or reports, or you've taken part in them. I know that many people in the campaign have taken part in, for example, parliamentary select committees and various other investigations and inquiries that have been going along the way. If you have any evidence that you think would be relevant to Module 2, the government high-level response to the pandemic, then have a good think about it and then supply it through Nicola, really, and we'll put it together in a Rule 9. Now, it's quite complicated about how far we can go with that, but if in doubt, just get in touch with the office about it. We are obviously trying to get evidence from you yourselves in terms of your lost loved ones and what happened. We think that they will resist that on Module 2, but if you think otherwise, then talk to us about that. In view of the time, that's all I'm going to say, but it is quite positive. They've asked us for evidence. We can send it in whether they ask us for it or not, of course. But if you think there's anything you have that's relevant to Module 2, then please, as soon as you can, get it through to Nicola.
Okay, thanks, Pete. And Nicola, I'm just going to come back to you before we move on to questions to just to give us an overview of plans to liaise with other core participants.
Yeah, no problem. So as you know from earlier comments tonight, a lot of other core participants have been appointed in Module 2 who are far more aligned with our views than the state bodies. So Elkin was very keen that we push to make contact with those organisations and have meetings. So Elkin has pushed ahead with that, and earlier this week Elkin and I met with a group called Just Treatment and Stop AIDS. Now, these are organisations that focus on ensuring access to medication and medical innovation. They look at the intersection between the interests of the patient as opposed to the interests of the corporation. So they applied for CP status in Module 2 with a focus of how the pandemic hit marginalised groups in the UK, and also on the basis that they attempted to influence the decision-making of the government via its campaigns. Now, they were unsuccessful in their application. And one of the concerns they have is that this echoes the selective listening that was carried out by the government throughout the pandemic. So they were chatting with us about how they make sure that they get their evidence in front of the chair in any event. So in particular, they want to share the stories of those living with the consequences of government decisions, such as access to vaccines. They also have research papers on the impact of the pharmaceutical companies and the lack of transparency in the government tender process. And they plan to apply for CP status in later modules, focusing on the impact of the vaccine and on vulnerable groups. And then last night, Elkin and Emily Driver, who's a trainee solicitor with our firm, they attended a meeting with a number of core participants who together have formed a collective called the Civil Society CPs. So in addition to bereaved family teams, this collective includes the Disabled People's Organisation, Long COVID Group, the TUC, Save the Children, the Children Rights Alliance, the Public Interest Law Centre. And the broad themes that emerge from that is, without Elkin even having to say a word, they were of the view that the inquiry is treating them as us, like we are irritants, and they don't actually want any input from them or us. So they also said that the impression they are getting is that the inquiries say they want to hear from us, but then they dismiss any contributions we try to make. So as you've heard from Pete, the group has been served with a Rule 9 request. And a number of the other CPs at the meeting last night have also received Rule 9 requests, but none of us have been provided with any funding to reply to the Rule 9 requests or to gather all the material. So they are talking about collectively writing to the inquiry in one voice and basically saying that the deadline should only come into play once funding has been agreed so that we can all do this work. But this is the first major step where all of us CPs are able to come together, put a joint letter in front of the chair so that she knows we are all speaking with one voice on behalf of all of these groups. So I know it's not been a great night in terms of news tonight, but hopefully this is a positive direction of travel.
And thanks for that, Nicola. And just a question that we've had in relation to that. So will the idea be that we continue to work as closely as we can with the other core participants? And is that normal for inquiries?
Shall I answer that? Yes, we will work with anybody that we think are on the same page as us. Of course, there may be CPs who aren't. I mean, for example, government departments trying to hide things. But we will work with any core participant that we think share the same interests as you, and obviously we'll talk to you about it as we go along. So
Okay.
I think it's very important that we work to our strengths on that. So I think that's very positive.
Yeah, okay, thanks, Pete. Nick, this one is for you. It's in relation to module 3, and it's asking specifically, is because you covered some of the things that it's going to cover, like DNR, etc. But is it also going to cover the discharging of COVID-19 patients into care homes?
The module makes specific reference to the discharge of patients from hospital, but it's silent as to where those patients go. And whether those were going to care homes. So we do know from the terms of reference that care homes will be looked at in detail, and that's in paragraph 11 of the terms of reference. And that makes clear that they are intending an investigation into the steps that could and should have been taken into preventing transmission into the care home and around the care home. So if it's not specifically mentioned in module 3, we will seek clarification about that, but we also anticipate that there will be a later module that is more specific to care homes.
Okay, that's helpful, thank you. Pete, question for you now, and it's an issue that's come up on almost every webinar, and it's about the disproportionate impact of the pandemic on people from minority backgrounds. Question here says module 3 appears to make reference to this, but only relating to healthcare workers. Will module 3 scrutinise the impact on those who lost their lives and lost loved ones from minority backgrounds?
If it's anything to do with us, then a resounding yes to that. Right from the outset, we persuaded Lady Hallett that this whole area needed to be prominent in the terms of reference. She did. That's one of the few things she's actually agreed with us on, and that improved the terms of reference at the outset. Unfortunately, since then, in the scope for module 1 and scope for module 2, they have been deficient in not covering those issues and wider issues. So we've raised them on both of the preliminary hearings, and in our written submissions, we'll most certainly be doing it on module 3, module 4, module 5, and we will keep doing it because these are such essential issues.
Okay, thank you. Mira, unsurprisingly, a question about the M&C SACHI and their work with Public Health England. Is there a conflict of interest? And why do you think the chair has deemed this not to be an issue?
So I think, firstly, it's important to separate two things. When we talk about a legal conflict of interest, that's a really complicated issue and a really high threshold to get to until you say that somebody has a legal conflict of interest. Now, our position is that that's not the question that the inquiry should be asking. The question that the inquiry should be asking is there a perceived conflict of interest? Do people have confidence in these firms, or are they seen as being on a particular side, coming from a particular direction? And we absolutely do have concerns with regard to that. Now, in relation to M&C SACHI, what the inquiry has said is that they work with Public Health England, but that none of their work during the pandemic related to COVID. So they said it relates to smoking and related to mental health. Firstly, I'm not entirely sure that that's correct. And the reason for that is that Public Health England published their expenses when they expend over £25,000, they publish what they've spent that on. Now, in terms of the contracts for M&C Saatchi, there are contracts in relation to mental health. There are contracts in relation to smoking, but there are also 2 contracts which come from the expense area, effects of COVID-19 comms. And those are quite large contracts. So one of the contracts is for 132,000, and the other contract is for about £26,000. Now, we don't know, there isn't available any more detail than that the expense budget for those contracts has been paid out of Public Health England's COVID-19 budget. And even if it is correct that M&C Saatchi are working with Public Health England on other things, this is a long-standing relationship that M&C Saatchi have had with Public Health England since 2014. They have been in essence contracted to do communications for them. And when you have a company that is receiving a large amount of money from a key client like Public Health England, there is a concern that that's going to impact the work that they do. Now, in relation to 23 in red, the issue is even more worrying because 23 in red were directly involved in the Cabinet Office's COVID-19 communications hub. And the Cabinet Office is going to be the arm of the government that certainly during Module 1 and Module 2 was responsible for a lot of the key decisions that were made and for coordinating across government. So the idea that their work is not going to be impacted by the fact that they were involved in that it's very understandable that people would be concerned. We're concerned about that.
So what are we going to do about it?
So we would be very happy to put in submissions on your behalf, highlighting these issues, telling the inquiry why we are concerned, telling the inquiry that they need to worry about people's perception of how independent these firms are, and they need to think again about other options. We're in your hands about whether or not you want us to do that, but that's something that we're very happy to do on your behalf.
Yeah.
So that's something for the group, I think, who I know there'll be various of the directors on here tonight to come back to us on. Jessie, let me move on to you, if I may, please. I mean, completely understand we've not had, a lot of good news to talk about tonight. And one of the questions I've had in is that people might be thinking now that there's no point in making submissions for Module 3 if we're going to get a blanket no. Is there any hope that the chair will be receptive to our submissions for Module 3? Oh, can Jessie hear me? I can hear a little person in the background.
Can you hear me, Kerry?
Yes, we can hear you now.
Great, thanks. I mean, the first thing to say is it's obviously a concern and there's no hiding from that, and we haven't sought to do that tonight. We've made that very clear. The inquiry's approach is obviously a worrying one and it's not consistent with all other inquiries. I do fear that some of the submissions that we've made so far, if we make them again in Module 3, will be refused again. Now, that is bad news, all right? But I don't think that that's a reason why we shouldn't. I think it's actually very important that we should continue to make the relevant, correct submissions, and I'll say why. First, because they're right, and we shouldn't simply give up on them because the inquiry are currently taking a restrictive approach. That would be the wrong thing to do for a number of, I think, obvious reasons. Second, as Pete touched on, there will now be an increasing weight of numbers making the same submissions that we've already made twice, again and again. That can become more important and provide greater pressure as it continues to be made over and over. I realise that might seem dispiriting, but it can be an important aspect of trying to turn the inquiry around. Third, if things develop and there are problems because the inquiry has ignored what we've asked them to do, as I fear may be the case on things like the lack of transparency and openness over Rule 9 requests. Ultimately, if we keep making our submissions, they will see that we are correct. If we stop making our submissions, it will basically be accepted and taken by the inquiry as indication that we agree with what they're doing when we don't. And fourth, and I know this has been touched on in the chat because I've been keeping an eye on it, if it becomes necessary to escalate our concerns, and there are a range of ways of doing that, some of them have been touched on in the chat, which includes going more public about it, because things are not changing and that's causing problems, it's essential that we have consistently maintained our position as to why that will be a problem and why things need to change, so that we can say we've done that and the inquiry has essentially stopped that happening.
Okay, thank you for that. And that kind of leads me into the question that I'm just about to pose to Nicola, please, is that, you know, should we consider going to the press about this or hold off? What's your advice on that?
I know Pete will probably have something to say about this. There is definitely a role for the media to play in this, and we would never seek to silence anyone subject to reminding people of the confidentiality that is currently in play. However, once something is said in a hearing, then there's nothing to stop you saying anything. We do have a meeting with the inquiry legal team on Tuesday, which has been called a reset meeting, which is where we are hoping that we can kick off a slightly better working relationship with them. I don't think any of us are overly optimistic about that. And I think depending on the outcome of that, we will probably have something more of substance to tell you about what is the best way of working with the media.
Yeah.
I think Pete will probably want to say something on that too.
Yeah, just very briefly, you know, I'm all in favour of this reset meeting, and at all part of the people who are going to be there and try and turn this round. So that's a process which is really important. But I always take the view that you know, we do the work in the hearings, but in no way do we want to inhibit the campaign, which has run a fantastic campaign right since the start in spring 2020, a really effective campaign. And in no way would I want to in any way stop the campaign picking up any of these issues, subject to the undertaking which Nicola's just mentioned. But I don't think that's a big problem. So I think talk to the directors, talk to the campaign about how upfront you want them to be. It's really important that all the families are together, so there's no conflict over this. But I think Lady Hallett is going to bend to bad publicity. I do think that's a very important tool. So don't think that anything I say is going to be negative in terms of doing that.
Okay, well that's good to hear. With regards to people that feel that they've been excluded or they're not being listened to, is there a complaints procedure or a form of redress that, you know, is there somewhere that people can actually go other than coming on a forum like this? Is there an official complaints procedure? Maybe Pete or Mira, either one of you to take.
Short answer is no in terms of a public inquiry, because it's like it's a quasi-judicial process. Practically, again, we're back to publicity and the campaign saying that Lady Hallett isn't listening and Lady Hallett isn't engaging positively with the families or the group. I mean, people could write to her, but I don't know whether that would have any effect, but there's no official way of doing it now.
Okay, thank you. I'm just going to get one more question in. Someone saw a report today that the Cabinet Office have been very late in responding to requests from the Parliament hearing into ex-PM's behaviour. Will they be able to act in this way when asked to provide information to our inquiry or to the inquiry?
Only if Lady Hallett lets them. Lady Hallett has quite big powers to force them to do what they ought to do in a timely fashion. Unfortunately, we have had a flavour of this, though, because Hugo Keith was repeating what the Cabinet Office had told him, which was that it would take them 3 years to review, even on a first review of the material they had. And what I said to Lady Hallett was, how would you know? How would I know? You know, don't just assume that they're being accurate about their estimates of 3 years. If they put twice as many people on it, even if they're right, it would only take 18 months. You know, it's imperative that she chases people down, and she's going to stick to the time scale. She has the power to do it, and that's what we'll be encouraging her to do.
Okay, thanks for that, Pete. Sorry I've not been able to get through all of your questions, but you will get responses to the questions that have been asked this evening over the next few days. It has been a bit of a negative session, but please can I just reassure you all that your legal team are doing everything humanly possible to move things forward in a positive way, and they will continue to do so. Let me thank all of the panel for their contributions this evening. Let me thank all of you for attending. And I'll remind you that a recording of tonight's session will be sent to you at a later date. You'll get your answers to your questions either directly or if you go onto the Q&A section of the Brodie Jackson Cantor website. And finally, you'll be sent a questionnaire following this session. We really do welcome any feedback you have on these, because these are for you and we need to make them useful for you. So any feedback you want to give us on anything, on the format, the content, please do so. Thank you all. Have a good evening.